morning, everyone. This is Jennifer Spaith. I'm a partner in the patent group here at Dorsey, and we're going to go ahead and get started this morning. This is the January chapter of our interactive dialogue IP. This morning's topic is patenting and licensing when subject matter eligibility is uncertain. The idea of this particular series is to highlight practitioners with intellectual property experience around Dorsey's platform and to get sort of a conversational view and insight into some timely topics. And so the one that we've pulled together today, I think, is going to prove quite interesting to many of you. So we're going to talk about both patenting and licensing issues in this era of uncertain subject matter eligibility. I will be joined by Rhona Schmidt, who's a partner in our technology commerce group, sits in our Minnesota office. Rhona has a wealth of experience in licensing issues and will be heading up that portion of the conversation. Rhona, you want to say hi?
Hi, everyone. Thanks for joining us.
And Erik Nyre is an associate in the patent group, also sitting in our Minnesota office. And Erik has worked both on the patenting and licensing sides of this issue, and also is well acquainted with much of the case law that we'll be discussing today. Erik, do you want to say hi?
Hi, everybody. Good morning.
So looking at kind of why we picked this topic today, many of you may have heard about the increasing challenges as to subject matter eligibility in the patent field that is plaguing, I'd say, a wide variety of industries, as we'll talk about later today, including software and computer-implemented technologies, as well as biotech and other health fields. So there's a lot of uncertainty around what types of technologies are going to be eligible for patenting, and then therefore what even existing patents are out there that may have eligibility problems now that this case law has developed in a somewhat different way. And I think it's fair to say that there are therefore a lot of patent holders and licensees and licensors that are facing the prospect of potentially holding invalid patents. What if some of these patents are challenged under these newer eligibility standards, and what does that mean both for existing patents and those that are pending before the office? And so I reached out to Rhona in the hopes that we could provide not just a discussion about eligibility itself, which we could probably give several presentations on, and everyone would still be a little bit muddled as to what the standards actually are. But in view of that uncertainty, what are the implications for existing and ongoing licensing programs? And so I think that that's some of the really exciting material that we'll talk about today pertains not just to this subject matter eligibility quandary, but sort of what we can do about that in the licensing context, given that there is some uncertainty out there. So with that, we're going to begin by going over the state of the subject matter eligibility case law pretty quickly and in not a ton of depth, mostly just to set the stage and get everyone acquainted with the issue and sort of set the table for the licensing discussion. So Erik, do you want to move into the basics of that?
Sure. So as Jennifer mentioned, we won't get into too many of the nitty-gritty details, but a logical place to start the discussion is probably by going over what the Patent Act actually says about subject matter eligibility. So the statutory framework regarding eligibility can be found in Section 101 of the Patent Act, and this section provides in part that whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof, may obtain a patent therefor. So as you can see, the scope of patentable subject matter codified in the statute is actually very broad, encompassing any new and useful process, any new and useful machine, manufacturer, composition of matter, and including improvements. However, there are implicit exceptions to this broad rule that have been recognized repeatedly by the courts. In particular, laws of nature, natural phenomena, and abstract ideas themselves cannot be patented. And as we'll discuss, these exceptions have become relatively controversial in recent years. So the primary reason for this controversy is that recent case law has expanded the notion of ineligible subject matter to engulf things like software and business methods, as well as inventions in the life sciences, biotech, and medical industries. As you can imagine, this is going to impact many industries and companies and their intellectual property. A few landmark Supreme Court cases were especially critical in driving this change. I'll discuss them real briefly just to give some context. The first case, Alice v. CLS Bank, was decided by the Supreme Court a few years ago, 2014. The court in that case invalidated patent claims directed to mitigating settlement risk by using a computer intermediary between parties exchanging financial obligations. And the court's rationale for invalidating the claims was that simply using a computer as a third party to settle financial obligations amounted to claiming nothing more than the abstract idea of third-party intermediation. In other words, the court was recognizing here that it's 2014 at this point. Substantial progress has been achieved in computer technology, and merely using a generic computer to implement an otherwise abstract idea was effectively nothing more than patenting the abstract idea itself. In the second case, Mayo v. Prometheus, the court invalidated patent claims again, this time claims that essentially reflected research data that correlated metabolite levels for a drug in a patient's bloodstream with the likely harm or ineffectiveness of the drug. So basically, the patent claims pinpointed a metabolite threshold. Metabolite levels above the threshold were indicative of, or below the threshold were indicative of the ineffectiveness of the drug, while levels above the threshold represented a high risk for a potential overdose. So the court deemed these claims ineligible for reciting nothing more than a law of nature, which we mentioned was a judicial exception, because the method merely described a natural correlation between metabolite levels and drug effectiveness. And so importantly, the court also said that the steps taken to administer the drug and measure the metabolite levels were just routine, ordinary, conventional steps that could be taken by any doctor. So these two cases in particular laid much of the foundation for later courts to find patent claims ineligible. And as many of you on this call might be thinking, the trajectory that began with Alice and Mayo is now impacting many mainstream industries. These effects might be particularly strong in the digital health field. Companies in this space are often rooted at one end of the pipeline in scientific discoveries that may be now equated with natural phenomena and natural laws, such as those that we saw in Mayo. And at the other end of the pipeline with computer implementations of those discoveries, which now may be characterized by the Patent Office as generic computer implementations of abstract ideas, like we saw in Alice. So here, both types of technology now face high uncertainty, and so making the crunch of patent subject matter eligibility especially noticeable in this space. So identifying the most promising routes to patentability that can be taken to protect this type of IP is going to be increasingly important in the coming years, especially as technologies develop into more all-encompassing digital health approaches related to things like prevention, disease prediction, and health management. So we do have a simple, at least on paper, two-part framework for determining whether a patent claim recites patentable subject matter. So this test was actually established in the Mayo case. And the first step is to identify whether the claim as a whole is directed to a judicial exception. If it is, then the question becomes whether the claim recites additional elements that amount to significantly more than that judicial exception. So not just ordinary steps taken by a user to practice an idea, or like we saw in Alice, generic computer functions used to implement an idea. You can visualize the possible outcomes of this two-part test by arranging them in a chart such as the one shown on the right. So as you can see, there's no eligibility issues for claims not directed to the exceptions we mentioned, but you run into problems when the claims are directed to exceptions and they fail to recite significantly more than that exception. So this outcome is shown in the lower left, and this is what you want to avoid. So in theory, this sounds simple enough, but in practice, you can imagine that answering these two questions often becomes very fact-specific, complicated, and just unclear overall. So thankfully, in response to widespread confusion, the Patent Office has published guidance reports that provide real and hypothetical examples of patent claims directed to the judicial exceptions, and whether these exceptions are claimed in a manner that recites eligible subject matter. So this slide shows a few examples from the guidance report published in 2014. You can see on the left several abstract ideas are listed. These include methods directed to economic concepts such as hedging risk, establishing contractual relationships, and using advertising as an exchange or currency. Other ineligible claims are directed to organizing and moving data. Only 4 examples are provided here, but you can imagine that the rising popularity of things like mass data processing may be widely impacted by this particular category of subject matter. So a few examples that have been recognized up to this point as abstract include comparing information and using rules to identify options, organizing, storing, transmitting information. Also, claims directed to mathematical formulas are considered judicial exceptions. For example, claiming the Arrhenius equation for calculating the cure time of rubber. So on the right, and more in the vein of Mayo, the list shows laws of nature and natural phenomena that are judicial exceptions. Many of you remember the Myriad case, which dealt with gene patents covering isolated BRCA2 sequences that are, of course, highly implicated in breast cancer, and of course, the methods discussed in Mayo. So each of these examples shown on this slide represent claims directed to judicial exceptions. Whether these claims recite, whether claims shown here or whether similar claims reciting exceptions include additional elements that amount to significantly more under Part 2 of the Mayo test, can also be considered by taking a look at additional examples. And so again, thankfully, the Patent Office has provided some guidance on what constitutes significantly more. The most informative guidance is, again, in the form of examples. And the idea here most likely being that as patent attorneys, you can model or at least analogize your claims to some of these examples that the Patent Office has shown recite significantly more. So as shown on the left, claim elements amounting to significantly more may recite improvements to another technology or technical field. If the claims are directed to abstract ideas implemented on a computer, then improvements to the functioning of the computer itself, such as the efficiency or processing speed of the computer, may amount to significantly more. Affecting a transformation or reduction of a particular article to a different thing, this is a so-called machine transformation test. And also adding specific limitations other than what's well understood, routine, and conventional. And this relates to the court's concern that patenting abstract ideas, for example, could preempt entire concepts or entire fields of research. And so only by applying such concepts in peculiar or somewhat unusual ways may a patent be eligible for protection. Claim and limitations not amounting to significantly more, essentially the opposite, and those are summarized on the right side of the screen. So moving forward, there are a few things to keep in mind regarding subject matter eligibility. The first being that despite a great deal of public comment and most certainly arguing repeatedly back and forth with the Patent Office, patent examiners and judges are still constrained by the two-part Mayo-Alice framework. So this is still the basic starting point for analysis. This is the guiding light for subject matter eligibility. However, perhaps as a result of some of the pushback to the Mayo test, which a lot of people believe is overly rigid, increased emphasis has recently been placed on part one of the analysis, challenging that directed to inquiry. This is largely the result of the EnFish decision that some of you may be familiar with. This was decided by the Federal Circuit last May. One of the take-homes from this case is that the relevant question when examining a patent claim is not whether the claim simply involves a patent ineligible concept, but whether the character of the claim as a whole is directed to that concept. So this inquiry essentially places more of a burden on patent examiners to explain why a claim is actually directed to a judicial exception as opposed to simply involving one. So, and also claim elements involving specific solutions that improve upon pre-existing approaches may amount to significantly more. So in a nutshell, challenges to overcoming rejections based on patent subject matter eligibility absolutely remain, but there are a few new avenues that are becoming available for overcoming these barriers, and these avenues should definitely be kept in mind when drafting claims and certainly when responding to the patent office. So with this, I'll pass it back to Jennifer.
Yeah, thanks, Erik. So I think that outlines the problem pretty well. We've had a couple questions about specific items as to what where that line is in either natural phenomenon technologies or abstract idea technologies. And again, I think the difficulty here is that there's not a lot to be said for clear rules in any particular technology. We can draw this nice box, but the answers to these questions as to whether your claim is containing a law of nature or a natural phenomenon is itself difficult to answer and specific to both what you've described in your patent application and what you've claimed in your claim. And the answer to the next question about the additional claim elements amounting to significantly more than the natural phenomenon or the abstract idea is, again, quite specific to what's exactly in your claim and how important those elements are relative to what the court has articulated as being the law of nature. So it's just a very difficult area to be in, where then we get these fact-specific lists that you can analogize back and forth to. But at the end of the day, it can be difficult to draw bright line rules. So, we have worked with patent applicants in preparing specifications to best position those specifications for a finding of subject matter eligibility. People are focusing a bit more on how the technology is described in the application and focusing on how the technology has advanced to the state of the art and refraining from labeling certain portions of the claims as conventional or known. With claim language, we've had a lot of software applicants focusing more definitely on what's going on in the back end, on trying to differentiate what their computers might be doing from what people may have done mentally for many years. So just making those subtle changes in specifications and in the approach to what aspects of the technology are pursued for patent protection is where we are. Everyone is seeing eligibility rejections at the patent office much more frequently than they had prior to this line of case law. When things get bogged down with a patent examiner, ultimately, in view also of the changing landscape of the law, many applicants are appealing to the Board of Patent Appeals, knowing that they'll get a review of that decision maybe when the legal climate is a little bit more certain, but that also is going to tie a patent application up for potentially years in front of the board. Right now at the U.S. Patent Office, the average pendency, if you're going to go through a board appeal, from the time you file an application till the time that you have a decision from the Board of Patent Appeals once you have appealed from a decision of the examiner is 6 years. So that's quite a long time for a patent application to lie pending, and is also something that we'll be addressing in the context of licensing moving forward. So if we'll want to turn now from this climate of patent applicants who are facing these eligibility challenges in this uncertain climate as to both their pending applications and their issued patents, and talk about what types of concerns that raises in the licensing environment. So, Erik, are you going to pick back up with an overview of the framework there?
Yeah, thanks, Jennifer. As you mentioned, some of the effects and the repercussions of uncertainty regarding patent subject matter eligibility are now, unsurprisingly, extending into the practice of patent licensing. So here, a patent licensor and the licensee will often have very different concerns. The licensor is most likely going to be worried about attempts to invalidate a licensed patent, especially one that perhaps involves a judicial exception and then stands on shaky ground as a result. And then at the opposite end of the table, the licensee is certainly not interested in paying royalties for the rights to a potentially invalid patent. You know, the licensees are seeing these cases coming down and probably recognize the struggle to overcoming eligibility rejections at the PTO. So, and in addition, you know, the licensee is arguably positioned to care the most about whether a licensed patent is actually valid, and may, you know, therefore be the party with the greatest incentive to actually challenge the validity of the patent, which up until the late 60s, the traditional rule was that licensees could not challenge the validity of a licensed patent. And, you know, after all, the licensee is the party that's benefiting from the exclusive right to make, use, or sell the patent. And so, you know, why would the licensee be able to actually challenge the validity of that patent? Well, due to public policy concerns that I'll discuss, this traditional rule changed with a Supreme Court case called Nyre v. Adkins, and this established what is now commonly referred to as the Nyre doctrine. And this doctrine, as shown on the screen, sets forth that a licensee is actually not stopped from challenging the validity of a licensed patent, at least as a defense to an action brought by the licensor to enforce the agreement. That's just a reflection of the facts of this specific case. So in arriving at this decision, the Supreme Court favored the public policy interest in removing invalid patents, which is of especially high concern now, from circulation over the, you know, often competing interest in upholding contractual freedom. So this public policy has been described as unmuzzling licensees so that early adjudication of invalidity could actually pass then to the greater public interest. The doctrine also established that a licensee cannot be required to continue paying royalties during the time that the licensed patent is being challenged. So as a licensor, you may be able to include language in the contract that requires royalties to be paid until the licensed patents are invalidated by the last court of appeals. And for many of you, this may be even standard language included in most license agreements. In light of Nyre, this language may not be enforceable in the event that a licensee does actually challenge a patent's validity and stops paying royalties. So a 2007 case actually took things a step further. This is MedImmune v. Genentech. in this case tested the jurisdictional case or controversy requirement. This is codified in the Constitution. And MedImmune stands for the proposition that a licensee is not required to terminate or materially breach a license agreement before challenging the validity of a licensed patent. So as a result of these two cases alone, you have this moving body of case law that we discussed earlier that widely questions the validity of patents, especially those that involve the judicial exceptions that we mentioned, and this built-in preference by the courts for upholding the ability to challenge patents, even if it's the licensee that's doing so. So what does this actually mean from a licensing perspective? If an outright prohibition on a licensee's ability to challenge a licensed patent is not allowed, then what can be done from a licensor's perspective to protect against patent validity challenges? Well, this answer is not that necessarily that clear, and the options for protecting the validity of a licensed patent may be best considered on a spectrum. So as shown on this slide, at one end of the spectrum, contractual provisions may prohibit outright challenges to patent validity. And we know that such provisions will likely be deemed unenforceable in light of what we learned in Lyre. And then at the opposite end of the spectrum, contracts can be drafted to leave open every possible, conceivable incentive to challenging a licensed patent. And so while these contracts at this end of the spectrum will likely be enforceable, and certainly the licensees would be happy about these kinds of provisions, a licensor would most likely want to discourage, at least to some degree, challenges to the validity of licensed patents. So the compromise, of course, lies in the middle of the spectrum, where contract provisions leaving at least some incentive to challenge a licensed patent would fall. This is where the law is somewhat murky, as we'll discuss next. Higher courts have not necessarily settled on especially bright-line rules regarding the legality of contractual provisions that don't necessarily forbid validity challenge, but certainly discourage them in one way or another. One informal rule of thumb, however, is that the more punitive the provision, burdening a licensee from merely exercising its Lyre-protected right to challenge the validity of licensed patent, the greater the risk of unenforceability. So this is kind of the guiding principle that you can keep in mind when trying to decide how to discourage challenges to a licensed patent without crossing over into the area of unenforceable contractual provisions or structures. So with this general and formal rule of thumb in mind, I think Rhona is going to next talk about a few implications of patent subject matter eligibility on some more particular licensing practices.
Yeah, thanks, Erik. So we'll move from the case law now to the more transactional, what do we see type approach, and what can you do, understanding that we're in a gray zone and our clients need to understand we're in a gray zone when we're advising them of what to do here. But the question really is, what's the impact on the licensor and the licensee if the patent that's been licensed is invalidated? And with the framework of Lyre and MedImmune behind us, we know that the licensor can't rely on the doctrine of licensee estoppel to prevent the licensee from challenging the validity of the patents that is licensed. So the licensor has to figure out what it's going to do instead. And there's a couple of different things that the licensor can do. And of course, they're doing this because the licensor still wants to get some sort of value out of its intellectual property. First of all, they can structure the license in different ways to try to get around the fact that the patent itself is at risk. And then secondly, there's certain clauses that you can consider putting into the license agreement, and we'll walk through those two different areas. One thing to bear in mind is that the licensee also should be concerned about how the license agreement is structured and the clauses that are put into the agreement by the licensor. The licensee, of course, doesn't want clauses added to the agreement that are just penal if they challenge the patents, because that's against public policy and doesn't work with the backdrop of Lear and MedImmune. The licensee also doesn't want clauses that are put in the patent license that even if the licensee was never planning on challenging the patents, some third party infringes and then claims because those clauses are in the contract with all the different licensees of the licensor, it's patent misuse, and that puts the patents at risk for being unenforceable, and that affects both the licensor and the licensee. So even if you as licensee don't intend to challenge the patents or don't think you're going to when you enter into your license agreement, you've got to think about third-party infringers out there and how they would view those provisions if they became publicly available. And then, of course, back to what Erik said, as a licensee, you don't want to end up paying a royalty for something where you don't have a competitive advantage because the patent's invalidated and now you don't have exclusivity. So the two different approaches are thinking about what solutions that the licensor can put in place when they're structuring the license agreements, and then the clauses. So let's start with the solutions. And the first solution is licensing under a hybrid license. So a hybrid license is where you would license the patent that you're concerned about, as well as other intellectual properties such as trade secrets. And this is a common approach. You'll see it in many license agreements. And then even if the patents are invalidated, there's still a license to the licensee under the trade secrets that you can attach value to. The key, of course, is that you have to attach the value to both the trade secrets and the patents, and you have to do that in very clear language. So that's the first caveat of doing this, is being clear that the royalties that you're getting apply to both the patents and trade secrets. And then, because you cannot charge the same royalty once a patent expires or is invalidated, that's per se unlawful, you have to have some language in the contract that deals with the situation when the patents are invalidated or expired. And Jennifer mentioned earlier, some of these applications are taking a long time, up to 6 years, to get issued because of these rules. And you've got to think about that as well, and how long you would agree to pay royalties as a licensee on a patent application that hasn't issued. Typically, you agree to pay it for 2 to 3 years, but you don't necessarily pay royalties forever if the patent never issues. So you have to have language that states that the royalty covers both the patents and the trade secrets. You have to have language that states what happens if the patents expire or invalidate. And what must happen is there has to be a discount on the royalties to take into account the fact that the patent value has gone away. Sometimes it's known as a knockback rate, and we see this drafted in a couple of different ways. Sometimes it's agreed up front by the parties that the royalty is 5% as long as there's patents and trade secrets, but if the patents go away, now the royalty is 3% on the trade secrets. That's one way to do it. Another way to do it is to draft a process into your license agreement where you state what happens in the event that all the patents that cover the product are invalidated, and how the parties are going to get to resolution on what the royalty rate should be for the remaining trade secrets under the contract. So the big question for me, as someone who drafts these contracts, is always, well, the question that's always asked to me by clients is, well, how much should you discount it by? Which is it's a tricky question to answer, because there was a rule of thumb many years ago that patents have the most value. So unless you're doing something else, like licensing a very valuable trademark, you're going to assume the patents have the most value and you're going to knock back by about 50%. That was the rule of thumb. But Erik went further than that and did a little bit of research for us to help us understand what the case law is saying about discounts. And so he's going to take us through that.
So as Rhona said, it is a tricky question. We know that royalty rates must be discounted at least somewhat after the invalidation or the expiration of a patent in a license agreement. But of course, as is often typical, there's no bright line quantifiable rule or formula or equation for determining exactly how significant the discount must be. So instead, we have, again, a general rule that royalty discounts must clearly indicate that the license was in no way subject to patent leverage. So patent leverage is basically the idea that in a license agreement involving a patent, the patent likely provides the licensor with a certain amount of bargaining power to negotiate the terms of the agreement. And without a discounted rate for the license after invalidation or after expiration of the patent, there's really no way to tell what the bargaining position of the parties might have been and what the resulting license arrangement would have looked like had the provision for post-expiration royalties actually been separated or divorced from the patent. And so with this general rule in mind, a few cases have shed some light on what satisfactory discounts might look like, at least in a few particular situations. For example, in the first case shown represented on the slide on the left, Kimball v. Marvel, the Supreme Court in this case said, at least in dicta, that a licensee or a license that involves both a patent and one or more trade secrets could hypothetically establish a 5% royalty rate during the period of enforceability of the patent, and that would represent compensation for both the patent and the one or more trade secrets, and a 4% royalty rate after the patent is invalidated or after the patent expires, and this would represent payment for the trade secret alone. So this indicates that at least in some circumstances, even a 1% royalty discount would actually suffice to show that there is no patent leverage attempted to be included in the license agreement. A somewhat different set of facts were presented in another Supreme Court case, this one called Aronson v. QuickPoint Pencil. Here, the parties negotiated a license agreement for the right to produce and sell, I think it was a keyholder design, but they negotiated the license while the patent application covering the design was still pending. And here, the agreement required the licensee to pay a 5% royalty rate during the pendency of the application. But if the patent didn't issue within 5 years, then the royalty rate would be decreased to 2.5%. In the end, as often happens, the patent didn't issue within 5 years, and the licensee then challenged the enforceability of the continued obligation to pay royalties for the agreement. And the court ultimately upheld the royalty provisions of the agreement because the 2.5% decrease in royalty rate made it clear that the application played no part in the contractual duty to pay an indefinite 2.5% royalty rate. So a different set of facts here, but the basic idea is again similar. The royalty discount must reflect the absence of a patent, or in this case, a patent application. As a last example, the patent owner in that Marvel v. Kimball case at least made an argument that a 3.5% rate for a patent and a trade secret reduced to only 0.5% to a 3% royalty rate for the trade secret only should represent a satisfactory discount under this idea. And in the end, the court disagreed with this argument, but on separate grounds unrelated to the size of the royalty reduction. So this may at least indicate or suggest on some level that even discounts under 1% may be acceptable. But after showing these examples, I have to note that the enforceability of royalty discounts will almost certainly depend on the specific terms of the agreement at issue. So if an agreement licenses the rights to like 10, 15, 20 patents and one or two trade secrets, and maybe these trade secrets are tangentially involved in practicing the patents, and let's say all of the patents are simultaneously invalidated, well, then the discount rate will probably need to be much greater than the example shown on this slide, maybe 40%, 50%, 60%. So the value of the patents relative to the total assets licensed in an agreement should always be considered when drafting these royalty payment obligations. And as Rhona mentioned earlier, and as she'll, I think, discuss next, there are a few structural options that may be implemented in these contracts for dealing with this invalidity issue.
Thanks, Erik.
And Rhona, before you turn to some other options, I feel like we would be remiss if we didn't pause for a minute and talk about what those trade secrets should be that are licensed in a hybrid license. I mean, can they be just anything, and what's the interplay with the patents there? Do you want to just address, like, what is that trade secret part?
Well, yeah, I mean, I would expect it to be something that's relevant for what the licensee is licensing. So if they're licensing a manufacturing process, for example, and there's a patent that covers a particular part of it, but there's also 18 other steps that no one in the industry knows and that have been protected by the licensor, that would be something that they could license as a trade secret. There could be that they're licensing some technology in addition to the patent, and that's getting into the next other types of hybrid licenses. For example, you could license software as well as patents, and then the software would be protected, assuming that you've treated it right, would be protected by copyright and by trade secrets, and so that's a hybrid license as well. Other things that could be trade secrets could be recipes or anything else that you can think of that would assist the licensee in succeeding commercially and that they actually need in order to make, use, and sell the product or process that they're licensing.
And that are secret also, right?
Secret, yeah. I mean, that's the key. Yeah. If you haven't kept them secret as a licensor, they're not going to have value to them anyway, and so it's going to be hard to attach a royalty to them. It's not to say that you can't necessarily attach a royalty to them when they are secret, and if they later get disclosed, insist on continuing to pay that royalty. I mean, there's case law on that. But at least initially, you would, if you're a licensee, you're not going to pay for a trade secret that is published on the internet.
And we had a question, too, about adjusting that kind of split over time. If the parties, for example, expect that over time those trade secrets are going to become more valuable, could they anticipate that by specifying, that the portion delegated to those trade secrets increases over time or changes in some way?
I've not seen that, but I think it's a really creative solution if that's the fact pattern, and I would just encourage anyone who's drafting that into a contract to explain it. I mean, we go to a lot of bother to put clauses in these agreements when we're doing multiple patents, some of which are issued in different jurisdictions. You've got a worldwide license to be clear that the parties have agreed to one set royalty for ease of payment, irrespective of which patent covers in which country on the product. So, I mean, you can build language like that into your contract just to explain to anyone who's reading it how you came to the conclusion that you came to in some sort of justifiable way. So, I mean, I think that's a great example. Or suggestion. I've never done that, but I don't see why it wouldn't work. We were talking about hybrid licenses, and it's not just trade secrets that you could license. You could license the patents with trademarks if you have a trademark that you want on the product. And then in that case, depending on the strength of your trademark, you might try and justify a knockback rate that's much higher percentage of the original royalty rate. So, and you might be able to establish what that rate is just based on other uses of your trademark in different industries or other uses of your trademark in the license agreement. For example, we did a license agreement for a licensor where we licensed a patent and a trademark for a toy technology, and the customer, the patent licensee, was permitted to use the trademark on merchandise that was associated with the sales of the toys. So, for example, they could put it on T-shirts. And so we wanted royalties based on the use of our brand on the T-shirts too. And when setting those royalty rates, we wanted to be careful that, because if you set them too low, then your knockback rate's automatically going to be too low. And so you've got to come up with some decision about how valuable your trademark is or is going to be. And then if you establish that rate for the other use, that's going to end up being your knockback rate in the event that the patents are invalidated. And then, of course, you can do copyrights and software too. Software is a little bit tricky. If you're licensing software plus a patent, if the licensee doesn't have a right to develop their own code that reads on the patent, then it will be less tricky. If they do have a right to develop their own code, in addition to the software that you've given them that reads on the patent, then bundling the royalty might be difficult because, of course, they could instantly replace your code with their own code, and now there's no justification for the knockback rate if they're not using your code. And same issue, of course, if they're allowed to improve your software over time. So one thing when you're licensing hybrid IP, and I mentioned this earlier, you just need to be very careful in the language to make sure that the royalties post-invalidation or post-expiration aren't considered to be intertwined or inseparable from the patent rights. You want to make sure that you're clear that you're licensing a different sets of IP and that there'll be different royalty rates in the event that the patents become invalidated or expire. So another structural way to handle this is portfolio licensing, and that's, of course, only if you have more patents that you can license. But as a licensor, if you have multiple patents that could apply to the product, then your risk goes down because it's less likely that all of your patents are going to be invalidated. As the licensee, of course, the risk here is that if the key patent is invalidated and you're left with remaining patents that cover weak or dispensable features of the product, so they're not, even though you have some patent protection, it's not really giving you a competitive edge. Now you're paying a royalty at the same rate, even though you don't have the protection of that key patent. So you might still negotiate a knockback rate in the event that patents that are really important are invalidated, even in portfolio licensing. Another structural way to handle invalidation is to get upfront payment from the licensee. So you could front load royalty payments ahead of any validity challenge so that most of the value is already received by the licensor before the validity challenge occurs. Of course, that means that the licensee has to agree that they're going to pay all the money up front, which for many licensees might be an impossibility, particularly if they're a startup licensing from a university, for example. And it might also be a real gamble for the licensee to pay all that money up front. So if you can't get a big upfront fee from the licensee, you could consider structuring the royalties so that they're a larger number at the beginning of the contract and then gradually descending to a different lower percentage at the end of the contract, so you get value that way, more upfront. Or you could keep the royalties static throughout the term of the patent license, and you could offer a rebate to the licensee if the licensee doesn't challenge the patents. It's kind of an incentive for good behavior, like you do with your children. Another approach is to consider some other non-royalty business agreements so that the parties can share the risks and rewards of commercializing the invention in different ways, rather than a royalty stream. So, for example, the licensor could take equity in the licensee. And that works if the licensee is a one-pony show, if they have one product and the patents are licensed from that licensor that's taken equity. It might not work quite so well if the licensee has a number of products, because then the licensor taking equity in that company might be benefiting from products that are more successful than the one that it has patents covering. So it's all just based on facts and circumstances, whether that makes sense. Another non-royalty way for a licensor to get value is to receive some sort of cross-license in return. So if the licensee has something that the licensor wants, maybe that's a way that the licensor can get some value instead of having just a royalty stream. So other than the structural changes, what else can you do as a licensor, and what should you do? As a licensor, since Lear, you should include clauses in the license agreement that result in consequences to the licensee that challenges the patents. But you have to remember that spectrum that Erik walked you through. A clause is more likely to be enforceable if the consequence of the clause takes effect after an unsuccessful patent challenge. So if you have a clause that just penalizes the licensee for challenging the patents, it's less likely to be enforceable. If you have a clause that has a consequence on the licensee if they challenge the patents and they're not successful, it's more likely to be enforceable. Oops, sorry, went on too far there. So the first set of clauses that you actually amazingly still see in some contracts are no challenge clauses, and those are the clauses that state that the licensee cannot challenge the patents, period. And Erik, you were just going to give us a quick.
Yeah. It might seem like a foregone conclusion after Lyre, especially that no challenge clause that outright prohibits a licensee from challenging patent validity would be unenforceable. But it's at least worth mentioning that the facts in Lyre presented a slightly different situation in which the licensee was challenging the validity of a license agreement in response to an infringement action brought by the licensor. So the Lyre court ruled that a licensee is not prevented from challenging the validity of a patent in defense to an action brought by the licensor. But despite those specific facts, the basic thrust of the decision has unsurprisingly continued to be repeated and adhered to in subsequent decisions that do deal with no challenge clauses. There's a few caveats. The consensus being these clauses are unenforceable, at least in a pre-litigation license. However, the Federal Circuit at least ruled that no challenge clauses are enforceable if part of a litigation settlement agreement, and this most likely just reflects the fact that the calculus changes a bit after the validity of a licensed patent is actually upheld, and the bargaining power of the licensor is in many ways solidified. So we mentioned the public policy interest driving Lyre to challenge potentially invalid patents. Well, after litigation, or during litigation, the counteracting public policy is to encourage settlement, and so that is what upholds the enforceability of such clauses in that particular situation. And Europe might as well mention such no challenge clauses in a licensing contract are almost always not enforceable as an antitrust violation. So as Rhona mentioned, if you remember that disincentive to challenge spectrum, no challenge clauses would be definitely at the extreme end that discourage licensees from challenging and are more punitive than anything else. And so these are most likely unenforceable according to our general rule of thumb. But there are certainly other options for licensors, at least to discourage validity challenges, and these don't depend on forbidding licensees from challenging. And I think Rhona has a few examples to kind of close us out in the next slide.
Yep, thank you. So, so the next set of clauses are clauses that we come across pretty frequently, and again, all in the gray zone. There's not much judicial activity on whether these are enforceable or not, so we'll just walk through them quickly. Termination for challenge clauses are, as you imagine from the title, it's a clause that says that if the licensee challenges the patents, the licensor can terminate the agreement. There's support for these clauses in a series of Federal Circuit cases because they say that a patent licensee that challenges the validity of a patent can be subject to consequences. And so this type of clause is a consequence. If you challenge, you get terminated. However, if you put a clause like this in a contract and the licensee is continuing to pay royalties while challenging, which they're not required to do, you'll recall from the Lyre doctrine, but if they do continue to pay royalties while challenging, as a licensor, you're going to take a risk with this type of clause that the clause is going to be found unenforceable if you try to use it. And the magnitude of that risk is going to depend on where the court places that clause, given all the facts of the case on that disincentive to challenge spectrum that we talked about. There's a Hastings Science and Technology Law Journal article from 2011, which is referenced in one of the earlier slides, where the authors conclude that a licensor has little to lose by including this provision, but that they should couple it with other pro-licensor contract provisions, such as the royalty increase for challenge clause, which I'll talk about next. One thing just to think about when you're licensing and also sub-licensing, so as a licensee, you might be in the position where you're willing to accept as licensee a termination for challenge clause because you're willing to fight the fight about whether it's an unenforceable clause in the event that you choose to challenge the patent. But if you are also sub-licensing the technology and the licensor is requiring you to pass through that termination for challenge clause to your sub-licensees, now you're stuck between a rock and a hard place because now you've got to try and sell this to all of your sub-licensees and hope that it's enforceable with them. So when you're piggy in the middle like that, it gets a little bit harder to figure out how you're going to approach this in your license agreement. The royalty increase for challenge clause is a clause that states that the royalties increase by a percentage in the event of a licensee challenge, and we've seen them cover two different increases. One increase was an automatic increase during the pendency of a challenge. It seems to us that that's likely to be unenforceable because it's an automatic penalty for the mere act of challenging. So it seems more on the left of that disincentive to challenge spectrum. But a clause that seems like it might be more likely to be enforceable is a clause that says if the challenge is unsuccessful, the royalties will increase because at that point, the patent's been adjudicated as valid and so arguably has more value, which would justify the increase. And we've seen ranges for increases of double to more than double the royalties in the event of an unsuccessful patent challenge by the licensee. It may also be important to include a clause like this in your contract because if the licensee challenges the patent is unsuccessful, and then the licensor wants to get out of the contract and wants to stop the licensee from using the patents going forward, there's a string of cases that say that the licensee can't get equitable relief to stop, the licensor can't get equitable relief to stop the licensee from using the patent because you can't get equitable relief if damages would make you whole. And since the licensor was willing to license for a royalty originally, why wouldn't the licensor be willing to license for a royalty once the licensee is deemed to be infringing because they no longer have a right to use the patents? And so if you put a clause saying in the event of an unsuccessful challenge, the royalties double, that gives you a data point to say to the court, hey, look, okay, I'll agree to a royalty rate, but look, we agreed that this is what the royalty rate would be in this circumstance. Other options are things like requiring the licensee to pay the litigation costs of the patent owner. Again, if you require them to pay the costs during the pendency of a challenge, it might be considered more of a penalty. If you require it to be paid upon a failed challenge, it's possibly more likely to be successful because you put the licensor through all the hassle of the litigation and you didn't succeed, and so now you should pay the licensor's costs. You can also require the licensee to provide advance notice of litigation, which puts you in the position as a licensor of having a heads up so you can prepare a defense. And it also gives you the opportunity to get together with the licensee and figure out what their problem is, and maybe you can negotiate a resolution rather than going through an entire challenge, which, especially if you have multiple licensees, that might be a valuable approach. And then, of course, you want to make sure that your confidentiality clause in your license agreement doesn't allow the licensee to use your confidential information against you in the event that they challenge the patents. So when you're drafting clauses like these, and there are multiple other options that other authors suggest, but I just wanted to finish with a note on how to draft these types of clauses, which is consider doing them in a waterfall type approach like you do with a non-compete. So you're always worried with a non-compete whether it works geographically or based on the scope of what you're asking for. And you can do the same thing with these clauses. You can set, you could do like a termination for challenge clause, and second clause is royalty increase clause, and third clause is the notice clause. And then you also, of course, need a severability clause that says that if one clause is unenforceable, the remaining clauses in the contract survive. But that way, you're at least giving your contract the best possible chance to have some enforceable clauses in it. So Jennifer, I'll pass it back over to you.
Great. Well, thanks, Rhona. I hope that everyone has enjoyed this slightly different take on the patent eligible subject matter quandary, and Rhona's take on the clauses and structures of those license agreements. Also, if you'd like to hear more about IP capabilities at Dorsey in April, we are planning the next of these quarterly webinars, and it will be on confidentiality clauses and recommended updates that our folks are seeing. And that will be myself moderating, Mike Droke and Chris Dirksen from our Labor and Employment and Corporate departments, respectively. If you have questions, all of us are also accessible at the numbers and email addresses here. So thank you all for joining us today.
Thanks.